Hi, this is Kip from Malek. Today I'm going to be talking about uh, physical injuries caused by stress. And I think I've made videos about how you could pursue psych claims through your workers' comp in Ohio. But usually, generally, you can't have a mental claim, i.e., you can't have a mental injury, causing a mental uh, claim. You can't get a claim allowed for that. For example, let's say you're a police officer and somebody pulls out a gun and that causes you PTSD or whatever, and then you file, like you didn't have any physical injury, and then you file a workers' comp claim because you're exposed to this very stressful thing and then it caused PTSD. So that would be a no-no, or it caused depression or whatever. That would be a no-no. If we go back, the Armstrong versus Jurgensen case again says that physical, like psych conditions, have to essentially be caused on a flow-through basis from um, physical injuries. So, i.e., you get a shoulder sprain or tear, and the pain and the treatment and all the fact that you can't work anymore due to your shoulder injury, that causes you depression. That would be okay. But if you're saying, yeah, again, my PTSD, or I was exposed to this thing and it freaks me out and now I've developed PTSD and depression, you can't do that. And we've run into situations where folks have, um, I had one individual who was running out of a building that was filling up with gas, and the building exploded. They didn't suffer an injury. Clearly, that would cause PTSD, but it's not allowed. So they didn't suffer an injury. Now, had they gotten burned a little bit or something, maybe that'd be an entryway to get the PTSD. But anyways, but you could get physical injuries caused by stress, which is kind of when you look at a mental causing a physical claim, which is weird. But it's weird because it's kind of unique in workers' comp realm. So this comes from this case called Ryan versus Connor, and in this fact pattern, or in the case, the underlying case, Supreme Court case, happened in the 80s. I'll post a link to the case in the comments. But this individual was told that he had to, he was getting forcibly retired, or he was going to have to retire, and that really stressed him out. He wasn't prepared to, be forced to retire. And then, so he went home and he was all kind of stressed out, but he was going to do yard work, and he ended up developing, he basically had a heart attack. And I think the guy ended up dying. And then, so the wife was filing a death benefit claim. And the court, did this whole thing, and they came up with two rules. And they say a physical injury caused solely by mental or emotional stress, you can do that, but there's a two-part test that the facts must pass. And then first, the injured worker must show that the injury resulted from greater emotional strain than to that which all workers are occasionally subjected to. So, if you're sitting in your office and, I don't know, you're having to do a lot of work and it's stressful, they might not look at it as that's being sufficient. It's probably going to be a factual thing most of the time, or a lot of times, unless it's something really. It's always going to be a factual thing, frankly. But unless it's something like really obviously crazy, it's it's going to come down to the jury, trying, or the hearing officer deciding, maybe that is something that, it's a greater emotional strain than that which all workers are occasionally subjected. And then, so that's the number one, you have to have that. And that's, again, kind of a factual thing. And then number two, stress to which he or she was subjected in his employment was the medical cause of his or her injury. So that mental stress that the person was subjected to has to be the cause of the mental injury, or the physical injury. So that's what does that mean? You're gonna have a doctor that looks at your medical records, and they're gonna have to say, yeah, this guy had a heart attack, and that heart attack was a result of whatever happened to him at work. And again, in that case, it was being told that you're gonna have to, you're forcibly being told you have to retire. But I got that case. I frankly, I would be kind of stressful, I imagine, but I don't know if that's, a lot of people are subjected to that kind of stress. So I'm not sure if that would, if you'd go to hearing for that, if they would, allow that claim nowadays. This happened in the 80s. The other thing that they were bringing up, if you read these cases, and I don't know if you do, but if you read the cases, there's a lot of dissension. And dissension means like some of the justices didn't agree with the decision. And some of it resolved around, well, the guy was doing physical labor at his house. How can you say that wasn't the cause of the work injury rather than this, stress at home? And frankly, you're making it didn't happen at work. He was doing the yard work at home, and it just, they were kind of not crazy about that. And there was other things they weren't crazy about, but that's that case. That's the case where we get the law. And then I think this is actually a better example of illustrating. So there's a commission order. You could look up full commission orders on the Industrial Commission website. I think I've done a video about that, but I'll have the link to where you can find those. But I think the date on this commission order was, I want to say March 1st, 2021, but it's regarding, I don't know if the actual case happened in there or the full commission order took place then, but be that as it may, so it's kind of crazy. But there's a sheriff was called to the scene of what allegedly was, this caller was saying, hey, there's people up in trees and they're shooting at me, and oh my gosh, you guys got to get here as fast as possible. So the sheriff drives to this location. It's out in the woods somewhere, and then he pulls up to this house. He gets out, and then he goes up to the house at the address, and it's the sister of the guy who called. And the sister's like, hey, he's holed up in his trailer, back in the woods. And she answered with a shotgun in her own hands, and she's like, yeah, he's up there. And so he's like, okay, all right, what's going on? So he's going up there, and this guy, this shooter, the caller, the 911 caller is like, hey, be careful, they're up in the trees and they're shooting. And meanwhile, this guy who's calling 911 is randomly shooting out in the woods. So he's shooting at the people in the trees, I guess. So the officer gets there, and bottom line is, I don't know, this dude's crazy, basically. I don't know if he's paranoid schizophrenic or he's on meth or whatever fun stuff this person is involved with. But he's got a trailer. The 911 caller has a trailer that's full of guns and all this other, militaria. And there was nobody shooting at him from trees. It was just, he's just insane. And so I don't know if the police officer arrested him. I assume he did something to get that guy under control. I'm assuming it wasn't, hey, there's nobody here, man, I'll see you. But be that as it may, he goes to his car, and he ends up having like a heart attack, myocardial infarction, due to the stress of this whole situation, i.e. this guy shooting in the woods and I guess maybe shooting past the police officer when he's going up to this trailer. And so he filed this claim, and the Industrial Commission found that the first and second factor applied. So, clearly this situation would be, the injured worker must show that the injury resulted from greater emotional strain than that which all workers are occasionally subjected to. I would say he probably was, because I would assume most workers aren't subjected to the type of strain that one would encounter whilst being shot at by a crazy meth guy. But so the hearing officer found that the first factor, or rather the commission found that the first factor applied, and then the second factor, the doctor basically stated the acute stress is a risk factor, likely for the myocardial infarction, and then the stress more likely caused the heart attack. So he had his doctor's opinion, the second thing, and you had the hearing officer found that the stress was kind of crazy. So that's Ryan v. Connor. So you could get physical injuries caused by mental or emotional stress. Okay, so that can happen, but there has to be a diagnosis of a medical doctor, and it has to be a condition. Yeah, so that's kind of I don't know, it's interesting. And I think they're kind of not crazy about that. I think the employer's bar, because it's weird, because there's wanting to they don't like mental claims, because they think, I don't know, people are going to be found like a ton of these mental claims, but there's been push, and I think some in the legislature, to make mental exceptions for first responders, like police officers, like this guy in this full commission order, ambulance drivers, you know, folks in that kind of line of work, firemen. So, but yeah, so that's Ryan v. Connor. Bottom line is, again, as I always say with all these videos, if you have a workers' comp claim, get a workers' comp attorney involved. Go search on Google, search workers' comp attorney or work injury lawyer or work injury attorney or workers' comp attorney, whatever. Find a workers' comp attorney, call them, give them your fact pattern, see what they have to say. If you want to sign up with them, cool. If you're not satisfied with their answer, call somebody else. But don't do this stuff on your own, because if you do this stuff on your own, you're going to make mistakes. And they're inevitably, when you make mistakes in this workers' comp field, these mistakes cause massive problems. You know, you miss an appeal, or you don't understand how you need this or that document, and you don't want to mess that up. So particularly if you're going to be off work for a while. All right. So you've been listening to Kip at Malek and Malek. If you have any questions, you could email or call the office. Otherwise, if you put them in the comments, I'll get to them when I can. Please stay safe. Don't get injured. But I assume maybe you're already injured. That's why you're listening to these videos. But hopefully your experience with the workers' comp system in Ohio is not overly frustrating. But by all means, 100% get a workers' comp attorney involved. I appreciate you listening to this. Thank you.